Welcome once again in the name of Allah the Beneficent, the Merciful. I bear witness that there is no God but Allah, and I bear witness that Muhammad is his messenger. Thank you once again for tuning in to Cairo Know Your Rights University. We are going over today another case law reading on constructive trust that we think would be informative and very educational to our viewing audience. So let us begin. As you can see, we have our screen shared. The case is called the County of Cook versus Edward J. Barrett. It's an Illinois appellate court case of the 1st District, 3rd Division. Let us begin reading. This is an appeal from the dismissal of the plaintiff's amended complaint for failure to state a cause of action. The County of Cook filed a complaint and an amended complaint in Chancery against the former county clerk, Edward J. Barrett, seeking the declaration of a constructive trust and an accounting for bribes allegedly received by him while he held office. Also named as defendants were the sureties on Barrett's official bond, the Fidelity and Deposit Company of Maryland, and the United States Fidelity and Guarantee Company. The defendants filed motions to strike, which were granted. In dismissing the action, the chancellor ruled that a cause of action of this kind by a public body to recover a bribe or kickback paid to one of its officers or employees or agents as a matter of law cannot be maintained. The amended complaint was composed of 3 counts. The county represented that Barrett served as the elected clerk of Cook County from 1956 through 1970, a position of trust, imposing obligations to faithfully perform the duties of office in the interest of the people of Cook County and not for the incumbent's personal gain. His salary for the position was fixed by law and was to be his only compensation for services rendered in the capacity of county clerk or any other capacity. Throughout the period of Barrett's tenure, the County Board of Commissioners at various times purchased and rented voting machines for use in elections. The board acted on the basis of contracts and proposals submitted and recommended by Barrett. By virtue of his office and influence with the board, his recommendations were tantamount to acceptance of the proposals tendered by him. During the same time, he was also charged with the responsibility to care for voting machines in county custody, which included the discretion to award contracts of insurance on the machines. Count 1 charged that Barrett abused his position of trust by employing it to seek secret personal gains from the Shoup Voting Machine Corporation, in that he caused Shoup to secretly pay him money that constituted fees and or allowances and or bribes, as a consequence of which the county paid considerably more money for the voting machines purchased and rented from Shoup than it would have otherwise. It was alleged that these payments from Shoup to Barrett amounted to approximately $180,000 for the years 1967 through 1970, but were unknown for previous years, and a detailed accounting was needed to determine the exact figure for the entire period covered by the complaint. The plaintiff prayed that Barrett be declared a constructive trustee for the citizens and taxpayers of the county for the amounts received by him from Shoup, and that he be required to account to the county for those sums. Count 2 also prayed for a declaration of constructive trust and for an accounting but arose from a different group of transactions. The remedy was invoked to recover secret payments received by Barrett from Arthur Gallagher and Company, an insurance agency in connection with his award of insurance contracts on county voting machines to companies represented by Gallagher. As in the first count, it was alleged that the amount of these payments for the period of 1956 to 1967 was completely unknown, that it had been approximated for 1967 to 1970 at $6,000, but that a detailed accounting was necessary to discover the exact figure by which the defendant had been unjustly enriched. Both Count 1 and Count 2 contain a number of parallel paragraphs setting forth allegations to justify an equitable accounting. In addition to averments that the arrangements between Barrett and Shoup and Barrett and Gallagher caused the county to pay more than necessary for their services and depleted its treasury by undetermined amounts, it was charged that the accounts would be complicated and that exhaustive discovery was required because of the secret and sophisticated nature of the transactions in the business of written records, and the absence of written records concerning them. The final count was against the sureties on the bonds Barrett had given for the faithful performance of the duties of his office. It prayed judgment on the bonds for the amount wrongfully and unlawfully withheld from the county by Barrett. The sureties filed a separate motion to strike and dismiss, but they offered no independent grounds, merely adopting the reasons asserted by Barrett in his own motion. Both in that motion and in his brief on appeal, Barrett has suggested numerous reasons why the county cannot recover from him. He contends that the county is entitled only to fees and allowances which are legally collected, that to allow recovery by a public body of bribes or kickbacks paid to its officers would be against public policy, that the county alleged no damage and suffered none, that no money moved from the county to him, that if any money was paid, it was paid by Shoup and Gallagher, not by the county, and that since no money moved out of the county treasury, it could not have been depleted, that the complaint did not allege that he had been unjustly enriched at the expense of the county, or that in the absence of bribery, the county would have paid less for voting machines or insurance. Attacking the equitable jurisdiction generally, he suggests that the facts alleged in the amended complaint did not warrant the grant of equitable relief, and that there was an adequate remedy at law. Attacking the constructive trust doctrine specifically, he contends that its application to one in his position would be unwarranted and unprecedented. It would be pointless to attempt to treat these contentious seriatim. We therefore will address them only insofar as they pertain to our discussion of the broad question raised by the judgment of the trial court, whether the allegations of the complaint stated a cause of action for a constructive trust. A constructive trust arises not by any agreement or understanding of the parties, but by operation of law, and is imposed upon grounds of public policy to prevent a person from holding for his own benefit that which he has gained by reason of a special trust or confidence reposed in him by an innocent party. Stated most succinctly, the purpose of the remedy is to prevent unjust enrichment. The particular circumstances in which equity will impress a constructive trust are as numberless as the modes by which property may be obtained through bad faith and unconscientious acts. Pomeroy's Equity Jurisprudence, section 1045 at 97. The barriers to its effective operation are few. The form of the property claim determines nothing, since a constructive trust will extend to reach real and personal property, choses in action, and funds of money. Pomeroy's Equity Jurisprudence, section 1044. To make out a case, a plaintiff must allege facts which disclose either actual or constructive fraud or an abuse of a confidential relationship. It is the latter situation with which this case is concerned, that is, an abuse of a confidential relationship. At all times, and for all the transactions pertinent to the complaint, Barrett was the fiduciary of the people of Cook County. As an elected public official, he held a position of the highest public trust. In the transactions with Shoup and Gallagher, Barrett acted as the county's agent, negotiating terms of purchase and recommending county action. An agent is fiduciary to his principal, and the relation is treated generally the same and with virtually the same strictness as that of trustee and beneficiary. Restatement, Second of Agency, Section 13. In deciding this appeal, it is not necessary to locate the perimeters of the fiduciary obligations due the public from their elected officials. It is sufficient to recognize that when such an official acts as agent for the public body in business transactions, he owes to his principal duties of loyalty and good faith, at least equal to those required of a private fiduciary in like circumstances. The obligations of a person who occupies the latter category are such that he must not place himself in a position which is adverse to that of his principal during the continuance of the agency. So he must remain loyal and faithful to his duty. An agent should not unite his personal and his representative characters in the same transaction, and equity will not permit him to be exposed to the temptation or brought into a situation where his own personal interests conflict with the interests of his principal and with the duties which he owes to his principal. Pomeroy's Equity Jurisprudence, Section 959 at 819. See also Riger versus Brandt, Commonwealth SS Company versus American Shipbuilding Company, Bone versus Hayes. The remedy for breach of this duty is simple and salutary. Since a fiduciary is bound to act solely for the benefit of his principal, equity will intervene to prevent him from accruing any advantage, however innocently, from transactions conducted in behalf of the principal. So, when a fiduciary who has acted for his beneficiary or principal receives a gift or bonus or commission from a party with whom he has transacted business, that that benefit may be recovered from him by the beneficiary of the fiduciary relationship. James versus First Federal Savings and Loan Association. In James versus First Federal Loans Association, it was alleged that the defendant lending bank procured title insurance for its borrower on mortgaged property and charged the borrower the full price of that insurance, but subsequently received and retained a 10% rebate from the title insurance company. The reviewing court ruled that under such facts, the bank held the rebate upon a constructive trust from the borrower as beneficiary in the absence of the borrower's express contrary authorization. The court quoted approvingly from the American Law Institute Restatements of the Law of Restitution and Agency. The Restatement of Restitution, Section 197, states, bonus or commission received by fiduciary. Where a fiduciary, in violation of his duty to the beneficiary, receives or retains a bonus or commission or other profit, he holds what he receives upon a constructive trust for the beneficiary. Comment A. Bribes and commissions. The rule stated in this section is applicable not only where the fiduciary receives something in the nature of a bribe given him by a third person in order to induce him to violate his duty as fiduciary, but also where something is given to him and received by him in good faith, if it was received for an act done by him in connection with the performance of his duties as fiduciary. Thus, if a trustee or corporate officer or an agent entrusted with the management of property insures the property in a company of which he is an agent, and he receives from the company a commission for placing the insurance, he is accountable for the commission so received and holds it upon a constructive trust for his beneficiary. See Restatement of Trusts, Section 170, Comment N, Restatement of Agency, Section 388, Comment A. Now, let me pause here for a second. I just want to state something that comes to mind. That statement there in the paragraph previously read brings to my mind how in the Bible it says, no man can serve two masters. He will either love one and hate the other, or hate one and love the other. This is just something I wanted to, express that came to my mind as I read that. Let us continue. C. Where no harm to beneficiary, the rule stated in this section is applicable although the profit received by the fiduciary is not at the expense of the beneficiary. Thus, where an agent to purchase property for his principal acts properly in making the purchase but subsequently receives a bonus from the seller, he holds the money received upon a constructive trust for his principal. The rule stated in this section is not based on harm done to the beneficiary in a particular case, but rests upon a broad principle of preventing a conflict of opposing interests in the minds of fiduciaries, whose duty it is to act solely for the benefit of their beneficiaries. Again, no man can serve two masters. The restatement second of agency, section 388, states duty to account for profits arising out of employment. Unless otherwise agreed, an agent who makes a profit in connection with transactions conducted by him on behalf of the principal is under a duty to give such profit to the principal. Comment A. Ordinarily, the agent's primary function is to make profits for the principal, and his duty to account includes accounting for any unexpected and incidental accretions, whether or not received in violation of duty. Thus, an agent who, without the knowledge of the principal, receives something in connection with or because of a transaction conducted for the principal has a duty to pay this to the principal, even though otherwise he has acted with perfect fairness to the principal and violates no duty of loyalty in receiving the amount. See Section 203 of the Restatement of Trusts. Upon examination, Barrett's argument that the remedy of a constructive trust has not been previously and as a matter of public policy should not now be applied to public officers accepting bribes reduces itself to the protest that no precedent exists which is squarely on point. Admittedly, up to the time his brief was filed, and no Illinois case had directly applied the doctrine in this manner, although the approach has received indirect endorsement in obiter dictum. Since then, however, a constructive trust has been imposed upon public officials, members of the Illinois legislature, and monies allegedly received by them in violation of their fiduciary relationship and duties. Futches versus Bidwell. But the mere fact that no precedent could be found in which such relief has been granted under a similar state of facts is no reason for a court of equity to shrink from action. The rule that equity looks to substance and not to form acquires special force in the realm of constructive trust. The rule that equity looks to substance and not to form acquires special force in the realm of trust, in the realm of constructive trust. One more time. The rule that equity looks to substance and not to form acquires special force in the realm of constructive trust. Wherever equity finds such a wrongful holding, it will give relief, whether the type of injustice is new or old. Wherever equity finds such a wrongful holding, it will give relief, whether the type of injustice is new or old. One more time. Wherever equity finds such a wrongful holding, it will give relief, whether the type of injustice is new or old. The court does not restrict itself by naming all the specific forms of inequitable holding which will move it, but rather reserves complete liberty to apply this remedy to whatever knavery human ingenuity can invent. The court does not restrict itself by naming all the specific forms of inequitable holding which will move it, but rather reserves complete liberty to apply this remedy to whatever knavery human ingenuity can invent. One more time. The court does not restrict itself by naming all the specific forms of inequitable holding which will move it, but rather reserves complete liberty to apply this remedy to whatever knavery human ingenuity can invent. Bogart, Trust and Trustees, Section 471. Despite the dearth of Illinois law on the subject, there is no logical reason why the remedy should not be extended to public officers in appropriate cases, the same as it would reach private trustees, employees, and agents. Despite the dearth of Illinois law on the subject, there is no logical reason why the remedy should not be extended to public officers in appropriate cases, the same as it would reach private trustees, employees, and agents. One more time. Despite the dearth of Illinois law on the subject, there is no logical reason why the remedy should not be extended to public officers in appropriate cases, the same as it would reach private trustees, employees, and agents. Indeed, such application is no new novelty. United States versus Carter. The facts of United States versus Carter are especially illustrative. In that case, the defendant, a captain in the Army Corps of Engineers, served as officer in charge of a vast public works project. His position carried with it large discretion, and numerous options were reserved to him as the government's agent in devising projects, drafting specifications, supervising, and accepting work. It was alleged that he exercised this discretion uniformly to create profits for certain contractors at the expense of the United States and received in return secret cash payments exceeding $500,000. The Supreme Court decided that Carter had violated his fiduciary duty to the government and that he, therefore, held the secret payments in trust for the United States. Proof of the particular methods by which he had augmented the contractor's profits or the effectiveness of those methods were deemed immaterial to the government's case. Barrett attempts to distinguish Carter as a suit in which the government paid inflated prices and traced the inflated sums into the hands of its employee, but this distinction is refuted by the court's own language. It is immaterial whether the complaint was able to show any specific abuse of discretion or whether it was able to show that it had suffered any actual loss by fraud or otherwise. It would be a dangerous precedent to lay down as law that unless some affirmative fraud or loss can be shown, the agent may hold on to any secret benefit he may be able to make out of his agency. The larger interests of public justice will not tolerate, under any circumstances, that a public official shall retain any profit or advantage which he may realize through the acquirement of an interest in conflict with his fidelity as an agent. The larger interests of public justice will not tolerate under any circumstances that a public official shall retain any profit or advantage which he may realize through the acquirement of an interest in conflict with his fidelity as an agent. One more time. The larger interests of public justice will not tolerate under any circumstances that a public official shall retain any profit or advantage which he may realize through the acquirement of an interest in conflict with his fidelity as an agent. The defendant's attempted distinctions of the cases cited earlier in this opinion also are futile. It would be absurd to predicate the availability of the remedy upon the manner or timing of payment of the secret benefit which evidences a fiduciary's conflict of interest when the relation of that benefit to the performance of tasks for his principal is otherwise undisputed. In related contentions contained in both his pleadings and brief, Barrett assails the county's complaint for its failure to allege damage. He states that the averments that the county paid excess sums because of his misfeasance are speculative and that there was no averment that he was unjustly enriched at the county's expense. The absence of an allegation of damage is immaterial. A constructive trust is not an action for recovery or compensation under the theory of contract or tort. It is a strict equitable doctrine applied to cure a fiduciary's breach of his duty of loyalty by erasing the source of his conflict of interest and transferring it to the innocent beneficiary. A constructive trust is not an action for recovery or compensation under any theory of contract or tort. It is a strict equitable doctrine applied to cure a fiduciary's breach of his duty of loyalty by erasing the source of his conflict of interest and transferring it to the innocent beneficiary. One more time. A constructive trust is not an action for recovery or compensation under any theory of contract or tort. It is a strict equitable doctrine applied to cure a fiduciary's breach of his duty of loyalty by erasing the source of his conflict of interest and transferring it to the innocent beneficiary. Bad faith is not an essential element of disloyalty, and good faith is no defense to the charge. Courts are not interested in a fiduciary's particular motive for accepting the payment or gift, but rather with the general effect of such payments or gifts. Nor are courts concerned with the question of actual damage to the beneficiary. The defendant suggests, too, that the county is not entitled to money which is not legally collected, and such money is the property of the person from whom it has been exacted. This contention was invited by the broad language of the complaint, which termed the payments by Shoup and Gallagher fees and or allowances and or bribes. It has been held that where public officers charge greater fees for the performance of ministerial functions than those prescribed by law, retaining the portion wrongfully exacted, the payers are entitled to the return of so much of the fee as is unlawful, and the public body, in the absence of statutory authority requiring that such funds be deposited in the public treasury, has no greater claim to the excess charge of the excess charge than the officer who fraudulently collected it. This is the gist of the several cases cited by the defendant. However, the rule has no pertinence to cases of bribery. However, the rule has no pertinence to cases of bribery. One more time. However, the rule has no pertinence to cases of bribery. I digress once again. I said that particular sentence 3 times because it brought to mind a previous case I read some time ago, uh, kind of similar to this, but it was stated in that case that limited liability is the rule, not the exception. Let us continue. The payments alleged in this case came to Barrett personally and were not treated either by the payers or the recipient as fees or allowances due the county. So Barrett is correct insofar as he contends that the county is not entitled to the money, i.e., it never held a claim at law on the funds. But that fact furnishes the very reason for the county's resort to equity to claim the money. Barrett errs in his view that Shoup and Gallagher retained a superior right to the funds. We know of no action cognizable at law or equity for the return of illegal payments knowingly and willingly made. The defendant argues that since the county seeks only a money judgment and the accounts are not complicated and discovery is unnecessary, it would be improper for Chancery to exercise jurisdiction over this controversy and thus deprive him of his constitutional right to a jury trial. This argument minimizes the underlying reason for equity jurisdiction, the trust aspect of the controversy. Wow, that's interesting. Let's read that paragraph again. The defendant argues that since the county seeks only a money judgment and the accounts are not complicated and discovery is unnecessary, it would be improper for Chancery to exercise jurisdiction over this controversy and thus deprive him of his constitutional right to a jury trial. Another thing that just came to my mind. It seems the defendant thought that, see, he already, in my opinion, as far as what I've read previously in this case, he has a conflict of interest in that while being a fiduciary or operating in an official capacity as a public officer obligated to perform specific duties as it pertains to his position, he secretly obtained bribes, fees, or whatever you want to call it, commissions or whatever. That's a private, and he merged his official interest or capacity with his private capacity. So in his private capacity, he thinks he has a right to a jury trial, but that's not they're reaching his misfeasance by way of, from what I understand from reading, by way of his, it says the trust aspect of the controversy. He's a public fiduciary. Well, let us continue. I digress. This argument minimizes the underlying reason for equity jurisdiction, the trust aspect of the controversy. The county seeks, first and foremost, a declaration of the people's beneficial interest in and the right to possess the secret profits accrued by Barrett in breach of his fiduciary duty of loyalty. The recognition, execution, and control of a trust or equitable interest is a matter exclusively within the jurisdiction of equity. Pomeroy's Equity Jurisprudence, Section 137. The jurisdiction is original, inherent, and plenary. The jurisdiction is original, inherent, and plenary. The jurisdiction is original, inherent, and plenary. So equity has original, inherent, and plenary jurisdiction over trusts. As Barrett himself has argued, the county had no claim at law on money which came to him from third persons as bribes. Nor can Shoup and Gallagher claim these funds. The very conception of an equitable interest requires the simultaneous existence of two estates or ownerships in the same subject matter. The one legal, vested in one person and recognized by a court of law. The second equitable, in another person and recognized by a court of equity. Under the circumstances alleged in this case, only equity applying this doctrine of the divisibility of legal and beneficial ownership is capable of doing substantial justice between the parties. Equity looks to substance and not to form. When Chancery exercises its exclusive jurisdiction to declare the county's equitable interests, it must then afford, as an incident, the complete remedy obtainable through an accounting. Where equity has jurisdiction for the purpose of granting equitable relief, the court may determine all issues of the case, whether legal or equitable. Where equity has jurisdiction for the purpose of granting equitable relief, the court may determine all issues of the case, whether legal or equitable. One more time. Where equity has acquired jurisdiction for the purpose of granting equitable relief, the court may determine all issues of the case, whether legal or equitable, including damages. The many cases cited by the defendant only serve to illustrate these distinctions. They were all accounting actions in which plaintiffs sought to invoke equity jurisdiction even though their primary rights and remedies were in law. Usually, though an action for money had and received, usually through an action for money had and received. Such being the case, the Chancery courts inquired into the complexity of the accounts and the need for extensive discovery. Where those factors were absent, plaintiffs were denied access to equity and remitted to their actions at law. County of Cook versus Davis contains a careful statement of the distinction. Davis was a county treasurer and invested county funds, but kept the interest for himself, contrary to law. The county filed a bill in equity for an accounting. In upholding the dismissal of the suit, the court said, the recovery here sought is of a purely legal demand, for which, if appellee is liable at all, the recovery could be had in an appropriate action at law. If the money alleged to have been received and not accounted for came to his hands as treasurer and is by law secured to be paid by his official bond, suit at law could be maintained thereon. If he received funds not within the contract obligation of his bond, but which he is nevertheless bound by law to pay over to the county, and action at law affords ample remedy for enforcing the personal liability of appellee therefore. Neither of these situations obtains in the present case. The bribes allegedly received by Barrett did not come to him in his official capacity as county clerk, and he is not bound at law to pay the money to anyone. Only one issue remains for our consideration. The original complaint asks an accounting for the period 1967 through 1970, but the amended complaint seeks an accounting for a much longer period, 1956 through 1970. Barrett expresses the belief that this change was made solely to justify an equitable accounting by fabricating issues of complexity and discovery. And his final contention is that laches and the 5-year statute of limitations on civil actions bars any action the county would otherwise have for the years 1956 to 1967. We have already decided that the accounting is incidental to the exclusively equitable remedy of constructive trust. Our disposition of Barrett's final contention therefore affects only the scope of the litigation upon remandment. The county argues the statute of limitations was told by Section 23 of the Chapter on Limitations, which provides, if a person is liable to an action fraudulently conceals the cause of such action from the knowledge of the person entitled thereto, the action may be commenced at any time within 5 years after the person entitled to bring the same discovers that he has such cause of action, and not afterwards. The county alleged neither diligent oversight of Barrett during the years covered in the amended complaint nor any affirmative act of concealment by him. Ordinarily, in cases of fraudulent concealment, Section 23 does not control unless the plaintiff could not have discovered the fraud through the exercise of ordinary diligence. Also, mere failure to disclose a fraudulent act usually does not suffice to show fraudulent concealment. There must be an accompanying affirmative act of concealment. However, these restrictions do not apply under the circumstances which give rise to this cause of action. When a fiduciary relation prevails between persons, it is not necessary to the preservation of the beneficiary's rights that he diligently search for the fiduciary's fraud. Nor should the existence of an overt act of concealment by the fiduciary be dispositive, for so long as one of the forms of trust relationship continues, the innocent beneficiary is disabled by the very nature of that relationship from acting to discover his fiduciary's misfeasance. We will not, through the application of a procedural technicality, contradict the very essence of the substantive law of trust, which is that innocent beneficiaries may rely implicitly on the loyalty and good faith of their fiduciaries. We will not, through the application of a procedural technicality, contradict the very essence of the substantive law of trust, which is that innocent beneficiaries may rely implicitly on the loyalty and good faith of their fiduciaries. One more time. We will not, through the application of a procedural technicality, contradict the very essence of the substantive law of trust, which is that innocent beneficiaries may rely implicitly on the loyalty and good faith of their fiduciaries. We hold that no part of the county's action was barred by the statute of limitations. Barrett's motion to dismiss admitted to well-pleaded factual allegations in the county's complaint. Barrett's motion to dismiss admitted the well-pleaded factual allegations in the county's complaint. One more time. Barrett's motion to dismiss admitted the well-pleaded factual allegations in the county's complaint. The allegations in count 1 and count 2 stated a cause of action for a breach of a fiduciary duty and for a constructive trust, and they should not have been dismissed, since the sureties have treated their liability on the performance bonds as contingent upon Barrett's personal liability. Separate discussion of count 3 is unnecessary. This count also should not have been dismissed. The judgment is reversed and the cause is remanded. Reversed and remanded. Thank you once again for tuning in to Know Your Rights University. We hope that the reading of this case has been somewhat of benefit to you, and that it may inspire you to study more, to show yourself approved, and to be able to assert our rights when necessary for the protection and preservation thereof. Thank you once again. Tuning out. Peace and blessings to you all.